You, in the California Law Review, wrote this, quote, diversity enhances the quality of decision-making. In addition to analyzing and applying the law, judges have to make determinations that draw not so much upon legal acumen, but on understanding of people and human experiences. Such experiences inform assumptions that affect legal decisions. At trial and in evidentiary hearings, judges have to assess credibility of witnesses. A witness's testimony may seem more credible if it is consistent with the judge's knowledge or experience, and conversely less credible if it remains outside the judge's experience. Simply put, a judge's lifetime experiences affect the willingness to credit testimony or understand the human impact of legal rules upon which the judge must decide. These determinations require a judge to draw upon something that is not found in the case reports that line the walls of our chambers. Rather, judges draw upon the breadth and depth of their own life experiences, upon the knowledge and understanding of people and of human nature, and inevitably one's ethnic and racial background contribute to those life experiences. Does that statement accurately reflect your judicial philosophy?
Well, let me put that in context, if I can, Senator. The point I was trying to make in that law review piece was that there is a benefit to having a diverse judiciary, that the judgments we make, some of those are based on deductive reasoning and analysis of the law, and sometimes they're based on more intuitive analysis, judging the witness credibility, making a decision with respect to bail or sentencing. That requires an understanding of human factors and different in various contexts. And the point I was trying to make is that the broader the breadth of experience, both for an individual judge and collectively as a court, I think the better the ability of judges to make those assessments. And I tried to give some illustrations in that piece about how the collegiality amongst judges, whether it's a formal exchange amongst the members of the Supreme Court or the Court of Appeal, or the informal exchange that often happens in the district court, in the hallways and in the dining rooms, that we learn from each other about various perspectives, differing perspectives and life experiences.
Well, you know, the average litigant would be nervous if he thought a decision was being made on what you judges talked about in the dining hall or in the hallways. I mean, the case should be decided, should it not, on the evidence introduced and the law properly applied to that evidence.
No, and I agree with that fully, and I didn't mean to suggest that cases are decided in the hallways.
Well, I'm just raising this point because it's something we've talked about before. I suppose your experience might help you have insight into a witness's credibility. Everybody has different experiences, and it might. But I was a little concerned that you say you might understand the human impact of legal rules upon which a judge must decide. You know, the oath says that a judge should do equal justice to the poor and the rich. I assume you would take that oath and intend to follow that.
Absolutely. I did take that oath when I was sworn as a magistrate judge.
And that you would be impartial.
Absolutely.
I know you served, 18 years as counsel for the American Civil Liberties?
16 years, actually.
16. And now you were on their payroll as a
staff attorney.
A staff attorney. Well, you know, the ACLU has filed some excellent cases. They filed some I'm not comfortable with. My time up.
Well,
I'm sorry.
It
You're
is,
right,
but I was giving
over.
you as
A warning.
in my role as chairman.
I
was giving you leeway because you're the distinguished ranking member, and I was torn